the Supreme Court's recent decision to take up a case over how the Justice Department prosecuted the Jan. 6 rioters has already postponed sentences for several rioters and could affect hundreds more cases, including Donald Trump's. If appeal is successful, Supreme Court could potentially expunge 2 of 4 charges filed by special counsel Jack Smith against former president in his federal election interference case and vacate felony convictions for dozens of Jan. 6 rioters. Since the Supreme Court accepted Fischer v. United States last month, more than a dozen defendants on Jan. 6 asked judges to halt their upcoming sentences and trials. While some justices disagreed, others granted the insurrectionist stay in a handful of cases. Last week, a convicted rebel currently in prison successfully won an early release set for May. Rebel Alexander Sheppard will serve only 6 months of his 19-month sentence. Depending on what the Supreme Court decides, he may then be released or may have returned to prison complete his sentence. Another rioter, Kevin Seefried, Delaware drywall installer known for carrying a Confederate flag into the Capitol, also advocates for similar early release. A few others were able to get their sentences suspended. That means they won't have to be convicted or go jail until Supreme Court rules on the case, which may not happen until end of June. Challenging DOJ conviction strategy. The lawsuit filed by Joseph Fischer, a former police patrolman from central Pennsylvania convicted of obstructing police line at the Capitol, lays out exactly how Justice Department secured felony convictions against hundreds of rioters on Jan. 6. In these cases, the Justice Department successfully argued that they had committed a crime by obstructing a federal investigation. The question Fischer raises is whether this law can be applied to congressional proceedings, such as the certification of the 2020 election that was interrupted on January 6, 2021. This is same law that Smith used to file an indictment on 2 of the charges against Trump in federal election interference case. The former president's lawyers plan to appeal obstruction statute in case if case returns to a trial judge before Supreme Court decision. A source told CNN. Trump's case is currently pending and the appeals court is considering the issue of presidential immunity from impeachment. Currently, the law in D.C. federal court is that 2 of Trump's 4 charges stand. Brandon Bell. But if the Supreme Court restrains or disagrees with the Justice Department, it could impact Trump's upcoming trial in March. This person said. The judge presiding over case, Tanya Chutkan, is unlikely to postpone his hearing if the case returns to her before Supreme Court decision in Fischer. If Trump's trial takes place before Supreme Court decision and Justice Department changes its authority to use law, it could lead to a retrial of Trump. Source said. The special counsel's office has already argued that